Welcome inside Brunch now until 12 o'clock. Let me start by welcoming the esteemed youngest at one time. That was back in 1979. He was the youngest senior counsel. He has many times appeared before the Privy Council. In 1980, he served as a temporary High Court judge under a temporary judge scheme. He's a very modest gentleman, so he's probably wondering, why are you blowing me up like that? He is Senior Counsel Martin Daly. Good morning to you, sir.
Good morning, Rennie. Yes, and you don't need to blow me up like that. Thank you.
I knew. I started reading it and I said, the humility in this man is going to come out. Rennie, you don't need to do that, okay? But you are, and whether you agree or not, you're still the esteemed senior counsel. You're the one that is quoted many places. You have appeared before the Privy Council. You understand what this is about. We are in a situation, sir. First of all, I hope you and your family is well.
Yes, we are. Thank you.
Good. We are in a...
One member of my firm had a bereavement through murder, so I'm a little subdued. But good morning to you and good morning to your listeners.
It's good to have you here, sir. I am going to, if you will forgive me, go back to your mother because she used a term that I would like to have explained to us. Explain what is it your mother meant when she said, we are talking about the judiciary. Obviously, if it is Martin Daly, you know what I'm talking about. Okay, good. What is the meaning of positionitis, sir?
Well, positionitis means that as soon as public officials assume office or shortly thereafter, they acquire a conceit and an inability to be objective and a contempt for the people around them. And those are the main symptoms of positionitis. My mother loathed positionitis.
As I'm sure you do too. That, I believe you proffered, may be the affliction affecting the former chief magistrate and former high court judge. As you say, she did not even apologize. But I must ask you, sir, did she not do so back in April 27?
No. My complaint about lack of apology has to do with the Judicial and Legal Service Commission.
The commission itself.
Who have committed, yes, it is them that I'm after for lack of apology. There are a few others as well, travelers to Tobago, phone charges and so on. But the JLSC has refused to accept one iota of responsibility for this huge administrative blunder. And even their latest statement, it does not betray any kind of apology or beg pardon. And that, of course, is one of the symptoms of positionitis. I'm never wrong. If I did something, it's either the other person's fault, my predecessor did it, my successor's going to do it. There's every reason why, other than I should shoulder any responsibility. And in many ways, that's one of the most shocking things about the actions and the action or omissions of a JLSC right now. They simply refuse to take any responsibility. And that, of course, has very serious consequences when we're talking about the judiciary. Because the judiciary are the people who sit in judgment on others and decide if they're right or wrong. And if they can't see the wrong in themselves, then obviously public confidence is going to be undermined.
They always tell me one of the things you don't do is get into the ball game and assume that everybody understands the game you're playing. Just in case you have been ostracizing, ostrich hiding under a rock, let me just make it very clear. We are talking about the debacle that we have in the judicial system where the former chief magistrate, and she became a high court judge and had to resign because of non-disclosure, not disclosing everything. And the JLSE is the Judicial and Legal Services Commission, set up to review such information, to basically vet information coming to them and go about making recommendation and appointments. That failed in this case, hence the reason of the resignation. The fact, Sir Martin Daly is my guest, the fact that the JLSC was operating one member short of its required composition, though it has since been corrected. Are there any actions taken before that last appointment that one will say should be vacated because they were not properly constituted?
Well, my view is that does not arise because of certain provisions in the Interpretation Act. Nevertheless, the fact that these very important bodies are operating with members short is just another symptom of a general slackness. I don't think in this case it will make anything null and void because of provisions in the Interpretation Act at the risk of repetition. But there's a general slackness about all these things,
Listeners, just to be clear, the head of the JLSC is the Chief Justice of Trinidad and Tobago, Mr. Ivor Archie. What is your position regarding the reinstating of the former magistrate as a senior magistrate, at least if only in the interim? I know the decision has been taken, that the cases will be reassigned and those part heard will be restarted. But what was your position with regards, why could she not be returned as a senior magistrate just to see through these issues, sir, these cases?
Well, I don't know under what powers the JLSC could act in order to reinstate her, or the word they used was restore her to the magistracy. I'm not aware of any legal process that permits that. And so I think that's one of the things that they got wrong when we start. The idea that having discovered this non-disclosure in an effort to avoid the monstrous injustices that are going to take place, they were going to restore her.
Mm-hmm.
And the Law Association and I, separately and jointly, and the Senior Counsel Group, have repeatedly asked them to tell us what is the legal process, or what are the provisions of the Constitution or an Act of Parliament that would permit them to do so. And they have stayed silent. So I don't know that was legally possible. Then, of course, there's the moral authority problem. Having hung, so to speak, hung Mrs. A.L. Caesar out to dry, it was difficult to see how she would have the moral authority to try anybody's case after such a public schooling, to put it mildly.
To put it mildly.
So I think they had two problems: lack of legal powers and having pretty much destroyed her moral authority, she wouldn't be able to sit with any credibility, and that would lead to all kinds of challenges in the courts, more expense for the state, and so on. This thing has enormous implications.
It is very interesting.
And it is very, very bad to put the judiciary in the firing line of public opinion. They'd love to lecture to us about the institutional independence, and the institutional independence must be preserved, and so on. But what about their institutional reputation? There are many very fine, hardworking judges who belong to the institution called the judiciary, and if the institutional reputation of the judiciary is undermined, it hurts everybody, including the hardworking people. Peter pays for Paul. And that's why I'm so strong on this, and they just got to pack these JLSC people, just have to pack up and go home.
The JLSC, does that also include the CJ who heads the JLSC, or are you talking about just disbanding the JLSC?
Well, no, they'll have to go home, and new members will have to be appointed.
You were very deliberate.
I don't think that if something is judged to be a huge and almost unfixable administrative blunder, that people don't go home just because of their position, then you're taking positionitis to an extreme. I'm very unhappy about this.
I understand.
Let me tell you, Rennie. Let me
Feel free.
Drink some cooling bush.
Take a deep breath. Senior Counsel Martin Daly is my guest this morning. Clearly, something that he's very passionate about, and because what the nation has had to go through with this. I do want to ask you this question, and here I come stepping on glass here. It is true that is a case of non-disclosure or not full disclosure, because as I read, 10 cases were disclosed, but a number of others were not. It numbered about
non-disclosure is material. Non-disclosure is a right to.
All right.
Sometimes an omission is as damaging as some piece of action. A material non-disclosure is the corrective.
Let me just thank you, sir. Let me ask you this then: was it so egregious, so it would eliminate her sitting on as a judge? I know you raised the point which you just covered a moment ago, which is the question of integrity. But this was not something criminal. This was not something. I mean, my question rather is: was it so egregious that there is no chance she could have sat and dealt with the cases that were there, or she can be, as you rightly said, restored to the?
I think 53 part-heard cases. Mm-hmm. Is an enormous, is a very big, it's a massive non-disclosure. And I think it's a question of moral authority, and people may well have challenged her restoration. I just think that the way in which they handled it, probably trying to throw all the blame on her and not show any blame from themselves, made things worse. But I'm very strong on this business about, you see, there's a wider issue here. And this is the issue of accountability. It's not every act or omission that provokes a general election. It's not every act of omission that produces grounds for impeachment. But there are some acts and some omissions that are so serious that people really have to quietly demit office, take responsibility, and demit office. And that's where public opinion comes in. We can't live in a society where the only remedy for something is to change a government every 5 years, because then you have 4 3/4 years to make a mess of things. And in any event, the public have no say in who sits on the bench and who doesn't sit on the bench. And if the judiciary rightly have all these protected terms of tenure, then they have a correspondingly higher duty to not to make these kinds of blunders.
Gotcha.
Because they're virtually irremovable. So public opinion, the reason I'm so passionate about this is I think this is an occasion on which public opinion is running in a certain way, and it must be respected.
It is a Herculean task you are looking at to remove the Chief Justice, should he not decide to demit office, and it all seems clear that he's not going to do that. So where do you see this going? In the case of the CJ.
Well, I don't know. The Law Association has a special general meeting of its members on Thursday coming June the 1st. And, a lot may turn on what happens in that meeting, how the debate goes, what resolutions are passed. This problem of these 53 partnership cases is not going away. Every time one of those accused appears in court, the matter is going to be raised again. So it's just not going to come off the radar. And the problem is far from solved. And the people who made this mistake must take responsibility, not just try to throw off responsibility on another person. This is not an issue about delays in the judicial system, which is a serious concern. This is a quite separate issue. This has nothing to do with how much money the executive gives the judiciary to run its affairs, whether the judiciary should have control over its budget. It's a question about accountability for a very serious administrative blunder, and that's the macro issue here. Apart from the specifics of the issue about not doing due diligence, not making straightforward press releases, and generally showing contempt for our intelligence, there is a macro issue of accountability in a situation like this. After all, when the mayor of Port of Spain suggested that a female murder victim, quote-unquote, he didn't use these words, but quote-unquote, look for it, public opinion reacted in a certain way, and he packed up and went home. And that is an example of public opinion making people accountable and having to take the fall for a big blunder. And this is a very big blunder. Now we're hearing this morning a new twist that when they had this meeting of stakeholders, quote-unquote, it included 6 judges. Now, if 6 judges took part in a decision to try these matters over, and that turns out to be wrong, then where does that leave their credibility? And in any event, of course, they won't be able to sit on any of these matters because they're wrongly, in my view, took part in the decision-making process. So they now are disqualified from sitting on any challenges to whether this is a correct decision.
Well,
that's another blunder.
It would be voluntary whether to recuse themselves or not.
No, the lawyers will make an application when their names are known. We don't. I mean, assume it is true. I don't have the facts, but assume it is so. This will be another blunder.
16.
And so it's just one thing after another.
16 minutes after 10 o'clock, all that is said with a period, I put on it and I hit the double space to come to this area. Because the question is asked in many different places, what kind of provision is in place should a magistrate who has part heard cases die? And go with me with this, please, senior counsel, because in the case she was elevated, and let us just assume everything was done, everything was good, but you had a couple of cases. What kind of provision is there right now? Should a magistrate who was part heard cases die? What happens?
Well, I don't think we have provisions that expressly cover that situation, and that is another thing. You see, another thing going forward, we have to look at what this experience is teaching us and what provisions we need to make. So, of course, you're right to raise that question, and I don't think there is a legal answer to that either. But to say that because there's no legal answer, if someone dies, then you must overlook what has happened in this case, of course. I'm not suggesting you say that.
Right.
And you see, this is another thing. There's the overall accountability issue. There are the specific things that went wrong in this case. Then there's the issue of what we are going to do for the future. And forming a committee to say how you're going to make or to make recommendations as to how you're going to appoint judges in the future doesn't make the people who have made this blunder, it doesn't make them accountable. You're trying to fix it for the future. It doesn't make them accountable. And we mustn't kind of be brambled by all these, tangents about what we're going to do in the future, what happens if somebody dies. Those are things we will have to fix going forward.
And you will appreciate that as senior counsel, because at any point, and not just even if a magistrate dies, but also at any point because of the delay in our judicial system, just about every magistrate is going to have a lot of cases pending. So we are saying that any opportunity for elevation is stopped automatically. I mean, they have no chance of being elevated because of the state of the judiciary. So it does raise the question, as you said, it is a teachable moment, a time for us to look and say, well, what are we going to do should a scenario of elevation or death come before us?
Well, no. In the case of elevation, the correct thing to do is if you have proper disclosure or you do your own due diligence, you say to the person, well, we are considering making this appointment. You have 2 months, 3 months, whatever, to clear the decks. Before the appointment is made official. That's what's done. You give people advance notice. I've been around a long time. When I used to do running down, I had a running down case where a young man was quite seriously injured in a road accident in St. James. And when the judge had reserved judgment for 3 years and 3 months, and then he got notice that he was going to be elevated, so he came and dutifully got rid of all of his judgment. But he left us with a belly laugh because he began by saying he had no hesitation in rejecting the defendant's account of the accident.
Whoa.
Had he hesitated, I don't know what those 3 years and 3 months would have been. But at least he cleared his decks because he'd been notified he was going up. And that's what's supposed to happen. So a proposed elevation should not produce this problem if the JLSC was doing its business properly. That we have no control over.
Yes.
In any case, people shouldn't die with 53 particles on their hands. It shows that the whole system needs addressing. But that doesn't alter the fact that how we're going to fix this in the future does not bring accountability for the current error.
The JLSC would not have even been close to this situation had due diligence been exercised. They were their responsibility because
but
regardless,
not accepting they had any responsibility.
Yes, regardless of what the chief magistrate handed to you, your business is there to go and vet, verify, and see. I got what you're saying. I do have another question that comes out of this. Senior Counsel Martin Daly is my guest this morning. This issue of those who had their cases part heard, it must start all over again. Who is paying for the attorneys for these accused now that they have to start in court all over again?
I wish we knew. And had they not just issued this simplistic press release about starting over and put some proper thought into this, they might have addressed that and might have made recommendations about that. And the other problem, that's one problem, and then, of course, there may be constitutional motions or judicial review applications arising out of it. It's going to cost the state money. And there's another much bigger problem. It appears that some of these 53 persons are not on bail. Now, putting aside murder, which is a special case, if there's anybody who's not been able to make bail or has had bail conditions that are too onerous to meet, then their bail situation needs to be reviewed as a matter of urgency. Otherwise, you're depriving them of the protection of the law and due process because their time in remand is being prolonged through no fault of their own. And to me, that should be the top of the list. What are we going to do about the persons who are not on bail other than the people accused of murder?
A tough situation indeed. I'm going to ask you, since you have, I'm sure, you sat in many cases where you had to bring two parties together, even when neither party was seeming to get an ideal fix. If the Chief Justice says, no, this question of resigning is not going to happen, and the Law Association is strong on the case that he should be because the integrity of the body itself is, in their view, irreparably damaged, what sort of median, what kind of solution do you think we can come to? I'm asking you going forward, how do you see this can be resolved? We
can't come to any solution until the person who has committed the wrong is prepared to accept that they're at least partly responsible.
But if you don't get that happening?
Well, I don't know what the public will say. It all depends. This meeting on the 1st of June is very important. I hope all members of the profession will turn up and express their views. I'm not prepared to say what I'm not prepared to make a prediction beyond the 1st of June because I think what happens in that meeting may have a certain effect on public opinion. It may dampen people's annoyance, or it may increase their annoyance. And I do think there comes a point where, however much you cling on, you're clinging out without any moral authority, and then people have to reconsider their position.
You will, of course, correct me if I am wrong on this, but I think I read where the AG office is asking for his folks to be sitting in on that special meeting.
Yeah, well, I don't know why he's getting involved in this. If the request is coming from him, I don't know why he's getting involved in that. I assume the request must be coming from the attorneys. But there's another problem. I believe there's a Court of Appeal judgment which says that they cannot vote in meetings of the Law Association. So that's going to be a little complication for the chairman of the meeting. But, I mean, the Prime Minister said there's a Chinese wall between the political executive and the judiciary. So one can only assume I don't know if the AG has said anything on this, but if he said anything, it means he's not fluent in Chinese.
We will all be cognizant, however, that with the old ways of Chairman Mao, there are many who are scaling the wall in the sense of their ideology.
So well, in Trinidad, they jump one way over the wall and then jump back another way pretty often, you know.
There is a distinct possibility that it may be a scalable wall.
Well,
I do want to ask you another question, and this one really pulls at the heartstring, because as much as I have heard opinions on this debacle that we're looking at, I have not heard one condemnation hitherto this incident on the integrity or the ability of Magistrate Caesar Ayers. And it does raise the question. Is her, in your opinion, if you care to hazard one, is her career over?
Well, I think she has some difficulties to overcome. I think she's already had a tremendous amount of pressure as a result of the what appears to be the material non-disclosure. I think she's been probably punished quite severely already, regardless of what happens to her future employment prospects. Some people are saying that we are making martyrs of her. There's no such thing. We've all said that she's wrong, but when people are wrong, you have to treat with them justly and mercifully. She's had bitter medicine, and unless she intends to bring some kind of lawsuit to set aside the resignation letter from the High Court bench, I think she has some serious difficulties. But this has moved beyond that. Her breaches of good order, if I can call them that, have been exposed. She has been publicly excoriated for it, and so we have to move on now. There's a bigger issue at hand, which is the responsibility of the JLSC at the time and going forward, starting with their inability to accept that they are at least in part responsible. And so that brings this wider, at the risk of repetition, wider question of accountability and answerability to public opinion.
It's a nasty situation all around. I looked upon her in preparation for us here this morning. I just had to go back to exactly what she said. She said, upon me mature reflection, I'm of the considered view that it would have been preferable that I advise the Judicial and Legal Services Commission of the full slate of my list and request further time to bring matters to completion before confirming my readiness to assume duties as a judge of the Supreme Court. She concluded by saying she regrets the effect of her action on those she strived to serve.
Well, hasn't she done? First of all, that appears to be an admission of the non-disclosure. We now know that it extends to 53 cases. She's resigned the appointment from the High Court bench, so she's lost it. It is pretty clear that she's not going back to be a magistrate. She's expressed contrition. Now we must treat her with mercy. I mean, she's paid, and she's in a very awkward position. And she herself has recognized that she did something wrong, which is more than can be said for the other parties.
Then I would implore the Law Association to do your Shakespearean part. The quality of mercy is not indeed strong.
Well, she has attorneys acting for her. They'll know what to do. But, I mean, I really think it's quite wrong to suggest that because we are upset with the JLSC, that we are somehow forgiving her or making a matter out of her. No such thing. This whole thing starts with her material non-disclosure, to which she has apparently admitted and for which she has expressed contrition and for which she has put herself in a bad position with regard to her future employment prospects. So kicking her around some more is not going to solve this problem.
Indeed.
Nobody's suggesting that she wasn't wrong. But, we have to deal with it, the bigger issue, and what's to happen with these 53 parted cases, and what's to happen with the people who are not on bail. And what's to happen if it is a fact that other judges participated in the decision to restart, if that decision to restart is going to be challenged. But we wait and see where the truth of that matter lies. I see it's an allegation, and I go no further.
We wait until June. Is it July 1st or is it June?
June the 1st.
June the 1st. June the 1st. Thursday coming is going to be...
Very important meeting
is going to be D-Day.
To do with accountability and the moral fiber of the legal profession.
Senior Counsel Martin Daly, always a breath of fresh air to have you. And I'm going to quote something that you never said, your mother said, but of the same era, I would think your mother at some point said, "Don't put water in your mouth."
Well, she very rarely did. In fact, she was a closet union organizer and a wonderful single parent, and defied the notion that everybody who is a product of a single parent mother is going to go bad. I do my best in her memory.
In her memory, yes, you surely have carried on that.
Well, I'm not. That's not for me to say.
Senior Counsel Martin Daly, thank you so much for taking the time to be with us.
Thank you for having me, and a good morning to your listeners.
I thank you, and you have a wonderful day too.